real important that the public have a right to that information. We're limited. There's lots of things we want to do that we can't do because of limited resources. The courts say we're not going to do one, and we can't control those kinds of things. So we kind of have to work within the system. Generally, like I said, preliminary hearings take a lot longer, take a lot more resources, and we need to be careful that we use our resources to the best possible use. Our resources are taxpayer dollars. I don't know. I honestly, I know there have been several cases. There's been more than the Camacho case that I had wanted to take to the grand jury, and that we couldn't because we couldn't find a forum. We couldn't find a judge that agreed with that. And it just, I didn't want to settle on a 5 or 6 or 7 month delay. I'm holding on the Vera Haskell case. I mean, I really need to get that moving, and you reminded me that I have not talked to Gary about it for a couple of weeks, and I need to check with Gary and make sure that that's on track. And I think that that's an important case. And I don't mind doing it in the cases where the integrity of the system is in question. Now, let me tell you, a grand jury is a secret proceeding, but the defense attorney has a right to a copy of the grand jury tape. So the defense attorney isn't denied a right of knowing everything that happened in the testimony of the witnesses. And of course, if they feel that anything inappropriate or improper occurred, then they always have the ability to approach the court and ask for a dismissal of that indictment. I can't think of that happening in the last 8 years. I mean, maybe I would say it's had to happen at some point, but I'm not aware of it. So even though the grand jury proceeding is a secret proceeding, it still is transparent to the defense attorney and to the defendant so that they can represent themselves. Okay? Did I answer your question?
Let me just say a couple of things. If we have a preliminary hearing rule, I guess that means we can have preliminary hearings. And out of however many cases in the last 8 years that only one deserved the public attention, I have a problem with that. The other thing about grand jury is I have personally filed motions contesting the propriety of the grand jury proceedings, and I know that other attorneys have also. Grand jury proceedings are extremely difficult to overturn, but really it's the power of the district attorney in that grand jury, and there are very, very limited times that you can overturn a grand jury, and they can come out with all sorts of charges that the DA later has to dismiss or that the defense attorney has to fight. The grand jury system serves a purpose, but it does not serve the entire purpose. And the other thing is I cannot imagine that if I did a request for a trial setting, that a judge is going to say, no, I don't have the time, we're not going to do a trial setting. In the other jurisdictions where I have done tons of preliminary hearings, you get the preliminary hearing setting at that time and you go to preliminary hearing. It's in the rules. You request a hearing, the judge can't say, no, I'm not going to do that. So, you know what, folks, here's the difference. You can go with the status quo and say, okay, she's right, you know, I'm okay with the grand jury system, we don't need to try new things. I'm offering an opportunity to really reform our criminal justice system, because when we start doing preliminary hearings, it is going to radically change the nature of how we charge cases. So you can go with the status quo. Ms. Brandenburg's been there 8 years. She has had time to implement all of her ideas and all of her programs and do anything new that she wants to do. 4 years ago, she was unopposed. If she wanted to really try something without repercussions, she's had that opportunity. If you want change in the criminal justice system and you want someone who has the heart to say, you know what, number one, I care about what's going on and I see that there's problems. Number two, I am willing to stick my neck out. I am willing to step out there and I'm willing to take the hits and say, I want to see something different because I'm not happy with what I see now. And she doesn't like the preliminary hearing system. She doesn't think it can work fine. I do. And if you want to give it a shot, give me a shot and I'll do the best I can for you. Thank you.
Is that preliminary system, is that a 60-day?
That's a really good question, and I've done some research on that, and I'm not sure that there's a solid answer. The rule provides that a preliminary hearing must be held within 60 days of the arraignment, and clearly, like on the case of Sergeant Andrew Gallegos, that hasn't taken place. So the question is, since Mr. Bregman concurred, because he was in front of the camera saying, you know, I concur with Ms. Brandenburg, we're going to take this to preliminary hearing. So since he said that on camera, I am presuming and know that he is a man of his word. And I would hope that there would be no motion saying, no, this is outside the timelines. But the system's set up for a preliminary hearing within 60 days. Now, if the defense attorney didn't concur in extending that 60 days, then you would probably have to take the case to grand jury. But I could not find any case law that supports that the DA can just get a continuance without the concurrence of the defense. And that's probably an issue that'll have to be decided. But you know what, when we have people sitting in jail for 2 and 3 years waiting for their final disposition, I guarantee you preliminary hearing will speed that up. Because what's gonna happen is you're gonna get pleas at preliminary hearing, you present the evidence at preliminary hearing, and the DA sees that they don't really have a good case, so they dismiss a preliminary hearing. When you start doing a preliminary hearing and you see the evidence, the defense attorney might tell the client, you know what, we need to work something out right now. You are going to clear out a lot of room in the jail, and you are going to clear out the criminal justice system, because things are going to get resolved early on. Let's say no deal was reached, no dismissal. You do a preliminary hearing, you take the evidence. The evidence is taken at preliminary hearing. The evidence is out. The interviews have been done. Now there'll be some more work that, investigations do go ongoing. So there'll be some more things. But what's happening now is that someone's indicted by the grand jury, and it is a year. She's right. I get continuances. Guess what? A good defense attorney continues a case. Why? Because witnesses forget, because evidence disappears, because cases get stronger for the defense. The longer a case takes, the better it is for the defense. And she's got people sitting in jail for 1 and 1.5 and 2 and 3 years waiting for their trial. And I'll tell you what happens then. After a person sits in jail for 1.5 years and the DA offers them a plea of probation, they're going to take it because they get out. And I'm not so sure that's always best serving our entire community. And we have serious problems, and I know this was focused on Native American, and I really tried to hone into just the Native American issues. But folks, do your research. We have serious problems downtown in the criminal justice system. And when you look at some of the cases, like Mr. Robert Gonzalez, who was held for almost 3 years, and he was mentally disabled, he had an IQ of 65, and she knew the DNA didn't match, and that case sat forever. And he sat in jail that long, and he was beaten up regularly in jail. There are serious problems downtown. If we had a preliminary hearing early on, the judge could have answered questions of competency, could have transferred that case immediately. Don't let this happen. Thank you.
And I don't, what this is about the Native American community, and I'm going to honor you by not getting into that kind of dialogue that I think is destructive and detracts from the Native American community. And so I'm not going to, trust me, I'm a lawyer and I have a lot to say, but I would rather honor the Native American community. Thank you for inviting us. I think that we have one of the best district attorney's office in the country, without a doubt. And I'm available, and I look forward to serving you all for another 4 years. Thank you.